Minority interest is one of the most discussed topic under mergers and acquisitions. Do you want to know more about it? Stay on to the video. Before even getting into the video, please subscribe to our channel and press the bell icon for the latest notification from our channel. What is minority interest? Whether National Company Law Tribunal will give importance to the minority interest? Will they take that into consideration? All that. These all are some of the important questions which will come to our mind when we are deciding on a merger and acquisition. What is minority interest? Before even getting into minority interest, let us try to understand what is minority. Minority or minority interest is not defined in Companies Act 2013. These are all terminologies which is basically evolved as precedents from the cases which is being evolved before the various courts in India, or the corporate law practitioners have evolved this particular terminologies. Minority shareholders are the shareholders who do not have control over the management of the affairs of the company. So generally what happens, like if you look at in any company, majority rule prevails. If I am a majority shareholder, if I say yes, the resolution is passed and the decision will be taken forward. Then what happens to the minority? So the interest of the minority shareholders has to be protected. That is the terminology called minority interest. What are the provisions which is there in Companies Act 2013 which tries to protect the interest of minority shareholders? That is what we need to analyze. It might be in various scenarios, whether it is in the form of a mergers and acquisition scenario, or if a majority shareholder is suppressing the rights of the minority shareholder. We call it oppression and mismanagement. Even in those cases, defining who is minority plays a very important role. By looking at the provisions of oppression and mismanagement as well as the compromise and arrangement provisions which is there in the company law, let us try to analyze. Minority means, in general, looking at the various provisions which is there in the Companies Act, a person is having up to 10% of the paid up share capital of the company, or a group of shareholders who are holding up to 10% of the paid up share capital of the company. This is relating to the company which is having the share capital. Now let us look into the company which does not have share capital. There are only members. Under those circumstances, they say 100 members, because I do not have share capital to count it for 10%. This is generally you will find it in various places, and those people will be considered as the minority shareholders in the company. Now how the minority interest will be protected? Please note, one of the important thing in case of mergers and acquisition process is, first the scheme will be drafted, and in that scheme the approval of the shareholders with a special majority is necessary. And there will be a group of dissenting shareholders. For them the sufficient opportunity has to be given. And if the minority shareholders are not happy with the scheme relating to mergers and acquisitions, they are eligible to move a petition before National Company Law Tribunal for objecting the scheme. They can object the scheme. That objection of the scheme is one of the important power what they possess under the provisions of Companies Act 2013. In addition to that, if they foresee any activity relating to oppression and mismanagement by the majority shareholders in the company, they have got every right to move a petition before the National Company Law Tribunal. They have got the right to receive the consideration. If the majority shareholders has agreed to the scheme and then they have agreed to a certain kind of consideration, even minority shareholders are entitled to same kind of consideration. In addition to that, the minority interest will be recognized in the financial statement, so that a provision will be created that what is the payment which might have to be paid after the dispute relating to the minority shareholders is over, or if there is no dispute, then what is the amount which has to be paid to the minority shareholders. So these are various ways, and at the end, while National Company Law Tribunal wants to give the approval to the scheme, minority interest will be taken into consideration. If minority interest is not protected, there are chances that the scheme itself will not go through. So this is the importance of minority interest under the whole procedural aspects relating to mergers and acquisitions. If you need more about, if you want to learn more about this particular subject on corporate restructuring law and insolvency, please fill up the Google form which is being given in the description box below, and you can even subscribe to our, or you watch our Telegram channel, and then for more details you can visit our Excel Academy website. If you have any questions, please comment below. We will be able to answer your questions. If you like this video, please share to your friends and then comment and then press the like button. If you need anything else in this particular topics as well as the subject from the corporate restructuring law and insolvency, please feel free to write to us. We will be able to assist you. Thank you.